Hello, good morning. This is Dr. Iftakhar Ahmed Ansari, Department of Political Science, Aligarh Muslim University, Aligarh. Now, so far I have been talking about the origin of state, and in that origin of state, we had been talking in my previous videos. I was talking about the concept of social contract. Now, social contract we have already discussed, like what Hobbes, Locke, and Rousseau said about the contract and how finally, according to them, state came into existence. Now, today's video, I'm going to compare Rousseau with Hobbes and Locke and then see the criticism of this theory of social contract that they presented. So here, Rousseau is compared with Hobbes and Locke. So Rousseau had drawn something from Hobbes and something from Locke. In fact, he began with the method of Locke and ended with those of Hobbes. So both Rousseau and Locke, they agreed that man in the state of nature was free and happy. The need for a civil society was felt with the emergence of certain disquieting affairs in the state of nature. For Locke, there were the inconvenience as a result of uncertainty in the application of reason, absence of a common judge to decide disputes arising therefrom, absence of a common authority to enforce the decision. But with Rousseau, it was the increase in population and dawn of reason upon men that was responsible for the conflict of interest and strife in the state of affair, because it generated the feeling of my and thine, and with that the rise of private property, and that necessitated a condition that can be controlled, because human nature had become, because of that competition, very selfish and egoistic, and it had become as bad as that of Hobbes, and the formation of a civil society by means of a contract was deemed the only way out. Both Locke and Rousseau agreed that the fundamental social contract ought to have for its end and object better preservation of the person and goods of every individual. That is, life, liberty, and property need to be protected. So Rousseau was also near Locke when he said that individuals surrendered their rights of the community, making the people ultimately sovereign and a source of political authority. Both Locke and Rousseau made the distinction between the state and government, though Rousseau maintained that the institution of government was not the result of contract. Both believed that the contract did not remove the supreme power from the people. Then we further find that Rousseau's voice is the voice of Locke, but the hands are those of Hobbes, because the influence of Hobbes upon Rousseau is indeed marked and very singular. With Rousseau, as with Hobbes, the natural man in the state of nature was absolutely independent of others. The only difference between the two was that with Rousseau, he was not at war with others, although eventually, when equality and happiness of the early state of nature was lost because of rise of private property and the competition, ensuing competition, it had made the people bring out the worst into them, and that worstness manifested in the form of the total war with each other. Again, we find that there was only one contract by which each individual surrendered all his rights in the case of Hobbes and in the case of Rousseau. And the authority of the sovereign to whom rights had been surrendered were strongly reminiscent of Hobbes, because here again Rousseau created a Leviathan. Although its head was completely chopped off, it cannot be recognized, because the Hobbes here was talking about Leviathan and Rousseau was talking about a Leviathan-like community which was entrusted with almost equally inalienable, indivisible, and supreme power, the sovereignty, which Hobbes assigned to Leviathan, Rousseau assigned it to the general will. Now, for Rousseau, the general will, which was the sovereign, and Hobbes, it was the king who was to be found the head of the Leviathan-like structure. But once Rousseau established the unlimited, all-embracing, inalienable, and general indivisible will, powers according as sovereign power in the general will. So he accorded that power to the general will, he endowed it with as much absolutism as Hobbes has given to his sovereign monarch. So similarly, to Rousseau could neither could neither be wrong nor unjust. It could even force the individual will to its own point of view. Now, are these not the conclusions that we also found that Hobbes drew about the Leviathan? So the only difference is that in the case of Hobbes, these are the attributes of a king, whereas with Rousseau, they belong to the general will. And what this general will precisely is, Rousseau remained throughout very vague and indefinite about it. In any case, both Hobbes and Rousseau make man the playing of the sovereign, no matter who the sovereign is, whether a king or a general will. Now, that was the comparison between these, basically Rousseau compared with Hobbes and Locke. And with that, we come to the criticism of the social contract theory on the whole, what Hobbes has said, what Locke has said, what Rousseau has said. Now we are on to the criticism and see how far this theory benefited the political science and the origin of state. So the doctrine that the state originated in a contract was a favorite theme of political speculation during the 17th and 18th century. But in 19th century, it was subjected to searching criticism. And even before the publication of Rousseau's Social Contract, Hume, the English philosopher, declared that contract as the basis of relations between the governor and the governed was incompatible with the facts of history. And Jeremy Bentham of England, he said that I bid adieu to the original contract and I leave it to those who amuse themselves with the rattle who could think they need it, and bluntly characterized it in the highest degree dangerous, since it makes the state and its institutions the product of individual caprices. So Sir Henry Maine maintained that nothing could be more worthless than such an account of origin of society and government as given by Hobbes. So we criticize the social contract theory of origin of state on historical ground. So historically, this theory has been regarded as false. The main point of criticism from this standpoints are like this theory assumes that man once lived without any social organization. Now this is basically unhistorical, as the modern anthropological studies have shown, and this theory divides human development into two, that is pre-social and social. Now this division is historically incorrect again, because human development is a continuous process. Now this theory assumes that state was deliberately created by a voluntary agreement. Now, there is nothing in the whole range of human history and anthropological studies to prove this point. Then the view of the state, and that to the nature of state given by various philosophers or these social contractualists, cannot be supported historically. Now, this theory does not show any consideration for customs and traditions and their role in social and political development. History shows that these factors, customs and traditions, they have played an important role in organized life of man. Now, this theory believes that before the emergence of state was completely free and could live as he desired. But this is historically untrue, as man has never lived in such a state of complete freedom. Now, this theory maintains that society originated because of social contract. Now, this is wrong, as society is natural to man, who is by nature a social being. In short, this theory is historically untenable, and it's merely a fiction based on some hypothetical beliefs. But all the social contract philosophers, they have conceived of this situation hypothetical. So considering hypothetical situation on historical grounds would be unfair to them and the premises and conclusions that they have drawn. Now, if we try to analyze this whole theory and see how it stands on philosophical and political ground, So we find some solid criticism of the social contract theory made on the basis of philosophical and political applications. The main point of criticism on these grounds can be summed up as, according to the theory of state and society, it considers state and society as artificial, man-made institutions created by man to satisfy some of his needs. Now, this view of state and society is unsound. As man is a social animal, he cannot live without society and social organizations. So, on this basis, the social contract theory has been attacked by idealist and utilitarian philosophers. Now, this theory assumes further that rights and liberty existed in pre-social, pre-political state of nature. But the theory of positive rights and positive liberty criticizes this theory on the ground that rights and liberties cannot exist independent of society and independent of state. So without any social recognition and political support, rights and liberty cannot exist. So the concept of natural rights in a state of nature, which is not a state of society, is thus self-contradictory, and T.H. Green has especially criticized this theory on this basis. Now further, this theory gives a wrong view of relationship of the individual, society and the state. The membership of society or the state is not voluntary, as no one can withdraw from its membership and say like I am no longer a member of the society or the state at will. So society and state ought not to be considered merely as a partnership in trade or industry, as these are the requirements of human nature itself. So the theory and its supporters take contradictory view of human nature, and on the basis of their analysis, no concrete theory of political obligation can be built up. And social contract theory establishes an absolute sovereignty, especially in the theory of Hobbes and Rousseau. Only Locke has supported a limited sovereignty. So this theory gives importance to individuals, whereas in social classes and their struggle is fundamental, this theory is built upon the equality of individuals in the state of nature. But this type of equality between individuals not found after the emergence of private property. Moreover, this theory tries to establish unity, law and order and peace in a class-divided society, without recognizing that unity in such a society is impossible. This theory maintains that state has been created by all the individuals taken together. This is not correct, as the state has been created by those who had something to defend against others, that is, by the possessing class. So the theory of social contract is indeed remote from actualities and completely oblivious to the facts. Nothing like the state of nature had ever existed. Even Hobbes himself, after discussing the state of nature, admitted that it never generally so. The most primitive people that anthropologists have described lived under a regulative system of some sort of rigid customary modes of behavior. So it is quite unhistorical to suppose that such men would resort to a contract. So the very idea of contract belongs to a later stage of social development than the hypothesis demands. So primitive man did not possess that maturity of outlook which the making of social contract presupposes. Moreover, the conditions of a contract also presuppose a system of law to support it, which was not there at the time. So the advocates of contract theory hold individuals as making a contract for their personal safety and the security of property. But history tells us the other way around. Early law was more communal than individual, and unit of society was not the individual, but the family. So the family was the unit, property was held in common. So customs formed law and each man was born into his status in society. Society has thus moved from status to contract and not from contract to a status as it has been maintained by a contractualist. So contract is not the beginning, according to Sir Henry Men, but the end of society. So in primitive society, birth determined the position of a man. It was not a matter of choice or voluntary arrangement of a slave. So let him remain a slave, the artisan, the priest. He is born. Now he who is born is the command of the status and cannot imagine a slave having free choice to contract. If he has a free choice to contract, then he is no longer a slave. So even if it be granted that state is the result of contract, common sense tells us that there has always been two parties to the contract. There cannot be one-sided contract as was conceived by Hobbes. Moreover, any contract lapses after the death of one of the contracting parties. It cannot be made legally binding on the descendants of the original parties to the contract. And Bentham here remarks, saying that I am bound to obey, not because my great grandfather may be regarded as having made a bargain which he did not really make with the great grandfather of George III, but simply because rebellion does more harm than good. That is why one can be kept in a bond of obedience. Now, further, it is assumed that contractualist that men are equal in the state of nature. Now, this assumption is incorrect. If status determined the position of man in the primitive society, then the natural inference is that of inequality rather than equality existed in the state of nature. Nor can we accept the human nature as it has been portrayed by the exponents of contract theory. The life of man may justly be described as life lived in groups, and while living with others, he is neither as bad as Hobbes and thinks, nor he is so good as Rousseau considers him to be in the beginning. Both Hobbes and Rousseau have allowed the intellect to be carried away by their imaginations. So the concept of natural rights and natural liberty, as it is said to have existed in the state of nature, is also illogical and fallacious. Liberty cannot exist in the state of nature. Law is the condition of liberty. Without restraint, liberty is the condition. Liberty is nothing sort of license, and condition of license is anarchy, pure and simple. So the state of nature being pre-political and even pre-social, it was subject to no civil war. Rights too arise in a society, and every right is accompanied by corresponding obligation. If there is no society, we cannot think of rights. No rights existed before the state arose. And finally, there can be no rights without a consciousness of common interest on the part of the members of society. And common consciousness was consciousness which was conspicuous by its absence in the state of nature. So without common consciousness, rights green, there might be certain power on the part of individuals, but no recognition of these powers by others as powers of which they allow the exercise, nor any claim to such recognition. And without this recognition or claim to recognition, there can be no right at all. So, if you further analyze on, let's say, a rational basis, the theory of social contract can no longer be upheld. The relationship between the individual and the state is not voluntary, that is for sure, and each one of us must compulsorily belong to the state, and the ties which bind men together are permanent. Each is born into the state. We are part of the state, and the state is part of us. So, Burke had aptly said that state ought not be considered as nothing better than a partnership agreement on a trade of paper and coffee, calico or tobacco, or some other such low concern, to be taken up for a little temporary interest and to be dissolved by the fancy of the parties. He says it is to be looked on with reverence, because it is a partnership in all science, a partnership in all art, a partnership in every virtue and all perfection. As the end of such a partnership cannot be obtained in many generations, it becomes a partnership not only between those who are living, but between those who are dead and those who are to be born. So that is the level of sacredness of the relationship that man enjoys with the state. So if the theory of social contract is accepted as a true origin of the state, it will make the state purely a handiwork of man, an artificial contrivance. But the state is neither the handiwork of man, nor the creation of God, nor the result of force. It is the product of growth and evolution, and many factors entered into the process of its development. Finally, the authors of the contract theory had no mind to trace the origin of the state. Their primary objective was to establish the basis of political authority and individuals' obligation towards it. And they were determined to prove certain results, and they wove a web of their own and in the manner which suited their purpose, and thus a contradictory theory has been presented as the origin of state. Now, all in all, if we see what value does it carry for us in the origin of state and its contribution to understanding the evolution of state itself, we find that we reject, therefore, the doctrine that the state originated in a contract. At the same time, we cannot discount the practical value of the theory. It has the advantage of giving us perhaps the only sound assumption on which to build and maintain any system of political relationship. It insists upon the fundamental truth that no stable state can exist without the consent of its members. Now, that is something that is very important, and it alone, the consent alone, makes the state. And then it further emphasizes that there is no state either before or without the people, and that the state has no authority except that is given to it by the people. So the relationship of the government to the governed is essentially one of contract or bargain, as obedience is conditioned on the government's fulfillment of its own part and doing that it is entitled to do by its charter, that is the constitution, and no more. So the principle of consent thus became an important factor in the development of political thought, and consequently it eclipsed the much talked of, until then widely accepted, doctrine of divine origin of the state. Now, this divine origin of the state lost its legitimacy with this contract, and contract theory gave a very powerful message that all governments and the state are the product of the individual consent, and they need to protect the individual's interest and regulate in their benefit and their welfare. Now, as Gilchrist, he points out, the chief enemy of the divine theory was this contract theory. Both Locke and Rousseau declared in most unequivocal terms that the monarch derives his authority not from the god but from the people, and he could continue to remain in office only on the condition of good government. So the contract theory, therefore, all in all, it served a very useful purpose in its time, and that useful purpose was combating the claim of the irresponsible rulers and their class privilege. So the contract theories also helped in the development of modern concept of sovereignty. Now, sovereignty was given, in fact, a concrete shape by Hobbes, and later on it was built by John Austin into a concept of sovereignty itself. So Hobbes was the one who paved the way for Austin, who was the exponent of legal sovereignty. So Locke was the champion of political sovereignty, and Rousseau was the high priest of popular sovereignty. So the concept of sovereignty itself gained most prominent support from these contractualists. So besides the consent of the people, and finally the shaping of sovereignty, and sovereignty lying with the people, I mean, that's what Rousseau was saying through his concept of popular sovereignty, which he calls it a general will. So it was the will of the people and the welfare of people, a public will. So Rousseau also brought into prominence the idea of a direct democracy. So indirect or representative democracy lost much of its appeal after the World War I. So new devices of popular participation in the work of government began to be advocated, and the referendum is merely, if we see, is a modified form of Rousseau's concept of inalienable sovereignty of the people. So this has come down to us in the form of a referendum that is so popularly propagated in democratic countries. So furthermore, the modern theory of a clear separation between the state and the government has really come to us from the contractualist. So contractualists have in fact uh, very profoundly, they have added into the evolution of the state, the concept itself, and understanding of it. With these features that we have discussed so far, the contribution of contractualists cannot be undermined, and in fact, they made a very important contribution in shaping the origin of and evolution of the state to the present state that we have. Now, with that, I come to the end of my presentation. Thank you for watching. Thank you.